want to introduce ourselves to the area of business law, which is a component of the whole program on business law and contract management. It is very important to have a knowledge of business law and contract law before you can really appreciate the course concerning business management or contract management, or what we call contract administration in some jurisdictions. So we want to start with the area of business law. Business law is not just one particular area of the law. It is made up of different aspects of law regulating business transactions, and the basic principles we get it from the contract law. Contract law forms the basis of any transaction so far as business is concerned. And so we will go into details with the contract law itself and see how the business law also operates within that context. Now, when we talk about the terms of a contract or vitiation or discharge and remedies, we are only referring to an aspect of the contract law we started already looking at. So we start with first the terms of a contract. The terms of a contract. The contents of a valid contract are basically all the information that constitute a contract, depending on the nature and type of contract. In construction contracts, for example, the context may include the terms in the offer, from maybe the requirement to be a form of tender or a bid form. It could also include the statement of acceptance, and that is award letter or letter of acceptance. Then we have the data information relied on for acceptance by submitted tender documents, then conditions and warranties of the contract, specifications depending on the nature of the work, the price, the time, and other agreements or agreed terms. In some cases, you need agreement form. If it's a building construction, then there will be the need for drawings, specifications, if any. If it's sale of goods, then we have to also talk about where the goods will be delivered, at what time, the venue, and all other specifications related to the sale. Then we need a basis for price, bill of quantities, and of course securities. All these will constitute the element of the content of a contract itself, the content of the contract. However, in some cases, such as in the construction contracts or procurement arrangements and any other sources of information may be instituted, and there could be other additional terms of the contract, and these may include minutes of the site meetings or any extra meetings you were holding will be part of it, instruction of the engineer or the person making the procurement or the client to the contractor, correspondence which has the effect of giving information to the parties will also be included. As an example, a letter from a contractor for submission of revised work program to the engineer or the client. Students should identify other relevant sources of information relating to their profession as part of the contents of their contracts. I'm only basing this on those in the area of maybe construction. If it's procurement, you also need some specific information in the area of procurement, which will constitute part of the contents of so it's applicable to any form of contract you need, not basically one, but any other area of contract. Now look at the terms of a contract. Terms of a contract are really obligations that each party undertakes, and the representations made in respect of discharging the contractual obligations. Term must be distinguished from mere puffing or boastful representation, which is intended to induce another into the agreement. So in representation, we make a lot of, especially at the negotiation level, we make a lot of promises, we make a lot of representations, and not everything will reduce or will be reduced into an agreement. Some remain just as a path, just to induce you into the contract. A term of a contract must be very clear and certain and not ambiguous. It must also be a condition or a warranty, depending on the expression of the intentions of the contracting parties. And the term of a contract may be expressed or implied by the parties themselves, or by the statutes, or by the courts. That is when it is implied. We look at these things into more detail. Now let's consider a very important element of a term of a contract, and that is conditions and warranties. Conditions and warranties, they constitute a term of a contract. Now, a term is either a condition or a warranty depending on the expression or the intentions of the contracting parties. First, let's look at condition. Conditions create the fundamental obligations of a contracting party. Some describe it as the central or the root of the contract, and if it is breached, will lead to the total collapse of the contract. It is the most important aspect of a contract, and if breached, can lead to some consequences. A breach of condition in a contract entitles the other party to repudiate the contract, to reject the contract totally, because you have violated the fundamental obligation of the contract. And the consequences, you may, or the other party may have the right to repudiate, to reject the contract, and even at times may ask for a remedy in addition. What about warranty? Warranties create also obligations, but minor obligations, and may also be representation that induces the contract or the contractual term of the contracts. They are therefore called minor terms generally. So a breach of warranties entitles the other party to damages only, but not repudiate, not to reject, but you could ask for just damages, payment of compensation in terms of money to the other party for the breach. And warranties, by effect of common law and equity, are normally the quantity expressed, the quality, the color, or time for performance of the contract, or the venue of delivery of the goods. They all constitute warranty. They all constitute warranty. Parties may, on agreement, however, turn a warranty into a condition. And that is the Ghanaian position as well. If the warranty is of a sense to any of the party. So when you look at the Sale of Goods Act 1962, section 16, subsection 2, it makes time of the essence to the buyer and not necessarily to the seller. If you see also section 23. So it means that in this case, under the Ghanaian law or statutes, time is already by statute reserved as an essence to the buyer, meaning it is already a condition and not a warranty. It has been changed into a condition for anybody engaged in a transaction of goods, a transaction that will require no repudiation. So we can look at some scenarios to explain this further, and I've provided some scenarios concerning two guys who were contracting over a sale of a car. Let's see where there is a major breach, which is a condition, and a minor one, the differences between the two. After delivered the Benz car, they plan to exchange or buy and sell a car, a diesel engine 2004 model, but has problem with some of the specifications given by Ben in the agreement. So this is an agreement between Alfred and Benz to buy a car, ship it to him in Ghana, and that was part of the transaction between the two of them. But when the car arrived, they had a problem. So the car was delivered, brought to them. That is the first scenario. And every specification was considered, but instead of a black color of the car, he got the color red. He could not also get the leather interior